now move to the professional standards case reviews, and I believe the first will be Sheriff Vanderkamp, which will be presented by Captain Kamp.
And that's number 8 for those on our agenda. And Captain Calpine, for the record, Deputy Director, will also be presenting along with Cindy Park, our compliance coordinator. This case is for Sheriff Kent Vanderkamp. On December 6, 2023, a complaint was received by the department regarding, at that time, Sergeant Kent Vanderkamp of the Deschutes County Sheriff's Office. The complaint was determined to be jurisdictional and forwarded to the Sheriff of the DCSO for review. On March 2nd, 2024, the department received additional information from the complainant, which was also forwarded to DCSO for review. In response to the information provided, the DCSO opened an internal affairs investigation. The sheriff notified Vanderkamp via memo dated August 15, 2024, that an independent investigator has been appointed to review the information provided in the complaint. The initial complaint was received prior to Vanderkamp's election as the Deschutes County Sheriff on November 5th, 2024. On November 14, 2024, a memo was sent to DCSO, then Sheriff Nelson, from the Deschutes County Legal Counsel requesting that DCSO refrain from issuing any disciplinary action / sanction above a level of a reprimand letter without first securing review and approval from Risk and Legal. A memo written by DCSO's undersheriff on December 5th, 2024, stated that DCSO closed the IA administratively. The memo indicated that the independent investigator was completed. However, the office did not complete the disciplinary process because Vanderkamp, who was now the sheriff-elect, went out on personal leave prior to a Loudermill hearing occurring. So on December 30th, 2024, the department requested documentation from the completed DCSO.
It's Jessica Adams, hide me pin.
A professional standards review was opened to determine if the reported behavior violated board-established employment training or certification standards for public safety professionals per Oregon Administrative Rule 259-008-0300 3F. On April 7th, 2025, the department was notified that the Deschutes County District Attorney's Office had completed an investigation related to false or misleading statements Vanderkamp made while testifying in criminal cases regarding his education. Upon completion of the investigation, the Deschutes County District Attorney determined that Vanderkamp had made false statements while testifying in at least 3 criminal cases, placed him on the county's Brady list, and stated Vanderkamp would no longer be called as a witness by the County DA's office. The department requested a copy of the DCDAO investigation and received that on April 9th, 2025. The department determined that the conduct being presented to the committee violates the board's moral fitness standards as follows. For dishonesty. 1, Vanderkamp was intentionally dishonest when he omitted previous employment or volunteer work as an Explorer Scout / Reserve Police Officer with the Los Angeles Police Department and a Reserve Police Officer with the La Mesas Police Department during his employment background investigation processes in 2004 and in 2008 with the Deschutes County Sheriff's Office. Item number 2, Vanderkamp was intentionally dishonest when he omitted that he was terminated for a cause from his position as a Reserve Police Officer for the La Mesa Police Department. Item 3, Vanderkamp was intentionally dishonest when he reported on 5 separate forms submitted to the department from 2008 to 2017 that he had not been discharged from a public agency. Number 4, Vanderkamp was intentionally dishonest during his interviews with the independent investigator on both May 23rd of 2024 and September 18th of 2024. Number 5, Vanderkamp gave false or misleading information while under oath regarding his education in 3 criminal trials, June 12th of 2013, October 3rd, 2013, and November 3rd, 2015 in Deschutes County, Oregon. Item number 6, Vanderkamp omitted information regarding his previous work as a reserve officer in La Mesa, California, while testifying under oath in criminal trials on June 12, 2013 and November 3, 2015. Misuse of authority, the department did not identify sufficient information to make a finding of misuse of authority. Misconduct, item number 1, Vanderkamp harmed the efficient operations of the Deschutes County Sheriff's Office and the public's trust by intentionally falsifying documents submitted to the department stating he had not been discharged for cause from a public agency by providing incorrect information on his DCSO background investigation and impacting the DCSO's ability to interview previous law enforcement agencies regarding Vanderkamp's performance and conduct as a reserve officer, and by giving misleading public statements and misleading statements to an independent investigator. Item number 2, Vanderkamp threatened or harmed the efficient operations of the Deschutes County District Attorney's Office and the DCSO when Vanderkamp provided false testimony while under oath that resulted in the DA placing him on the county's Brady list. Given this designation, the Deschutes County DA's office will be reviewing court cases involving Vanderkamp's testimony to determine if any action should be taken to protect the rights of criminal defendants and the justice system. Vanderkamp's dishonesty under oath discredits the law enforcement profession and the standing of the DCSO in the community. This dishonesty and potential reversal of justice found through court processes threatens the efficient operations of DCSO due to the negative impact of his dishonesty to the community. Chair?
Thank you. Scott Young for the record. It's my understanding that Sheriff Vanderkamp's attorney, Randy Harvey, will be providing mitigation. Is that correct? And if it's correct, are you online?
That's correct.
Okay, thank you, Mr. Harvey. Now's the time to provide mitigation. You will be given 5 minutes exactly to provide a statement. At the conclusion of that 5 minutes, you'll be able to ask questions and you won't be able to ask the committee any questions. And we will stop you right up. So how would you like to be notified when you're close? I guess if you were in the room, we have a clock in here.
Yeah, if you'd just give me a heads up when there's about 30 seconds left. I do want to, before my time begins, note some objections for the record.
That's not the time for this. This is the time only for a mitigating statement.
Well, I understand that, but we informed Ms. McAlpine before that we had some objections that some of the individuals who will be participating on this committee should recuse themselves because they had predetermined this and having already made a decision before this meeting.
Mr. Harvey, let me interrupt you for a second. This is the time for the mitigating statement. All of those other issues, this committee will make a recommendation, and that recommendation will be presented to the DPSST. And I think the other legal processes is where you would file those objections, not at this time. So I do want to make sure that we're sticking with our process, which is the same for everyone. And so this 5 minutes is for the mitigating statement and the mitigating statement only.
All right. Well, that's the first statement I'll make is we reserve the right to make our objections. We provided this committee, I'll begin my statement, we provided this committee with a significant written statement of our response to the investigation made by DPSST, prepared by my senior associate, Mr. Mittendorf, who had planned to make this statement today, but due to health considerations is not able to do that. The first statement of allegations has to do with dishonesty, that Mr. Vanderkamp, Sheriff Vanderkamp, was dishonest in terms of omissions that were made regarding his work for LAPD and La Mesa. Those statements of dishonesty are not factual. In fact, Mr. Vanderkamp disclosed that information to the DCSO Sheriff's Department in his initial application, was considered by the DCSO. That information is in our response. It was considered. Deputy Swift made that report to then Sheriff Stiles. It was in the Sheriff's Office files. Apparently Mr. Ferris, who conducted the investigation, and then Sheriff Nelson didn't see fit to provide that information in the report to DPSST, which led DPSST to the false conclusion that he misrepresented facts, which is an untruth. DPSST was drawn to the conclusion that Mr. Vanderkamp was intentionally dishonest when he admitted information or omitted to state that he was terminated for cause from a position at La Mesa. Again, that's not true. He was not terminated either for cause or otherwise from La Mesa. There are no facts in the record that that occurred. He was indeed not terminated for cause or otherwise from La Mesa. California, like Oregon, requires a procedure for that, including a Loudermill hearing. The law is specific in California. He was not terminated. There are no facts or evidence to support those allegations. Therefore, he admitted nothing in that regard. He was indeed not terminated. The report states that Vanderkamp was intentionally dishonest when he reported on 5 separate occasions to DPSST from 2008 to 2017 that he'd not been discharged from a public agency. Again, he was not dishonest because he was not discharged. Again, there's no evidence that he was ever discharged, and therefore he could not be dishonest if indeed he was not discharged. The report states, allegation number 4, that Vanderkamp was intentionally dishonest during interviews with independent investigator Ferris on May 23rd, 2024 and September of 2024 in reference to Ferris's report in discussing Vanderkamp's experience over 30 years prior in regards to work he did as a cadet explorer with LAPD and his time as a reserve officer. Ferris reported that he was dishonest because he didn't consider that time as experience as a police officer. Apparently, DCSO agreed with Vanderkamp because they required and didn't consider that as police experience when they required that he go to the Police Officers Academy when he was hired by DCSO. Officer Swift didn't credit that as police officer service and required that he go to the academy. That's in DCSO's files. Ferris and Nelson didn't consider that and did not report that information in their investigation to DPSST. Number 5, the report states that Vanderkamp gave false and misleading information under oath in 3 criminal trials on June 12th, October 3rd, and on November 3rd of 2015. The 2 previous were in 2013. The report is somewhat unclear about the facts that led to this determination. However, it appears these allegations relate to a curriculum vitae.
Thank you, Mr. Harvey. Your 5 minutes is up. I appreciate that. Okay, we're going to move to the next step where we're going to ask to adopt the record or return the record to staff. We're looking for a discussion on if any questions about the record. At the end, we'll be looking for a motion to adopt the record or to send it back for more information.
Why am I being muted?
Your 5 minutes is up, sir.
That was 5 minutes?
That was 5 minutes. Yeah, I gave you a 30-second warning, and then I let you know when the 5 minutes was up, and then we muted you. Okay, back to, we're looking for a consensus, I'm sorry. Consensus to adopt the record. Any objections to adopting the record? I'm getting a lot of thumbs up around the table. Hearing no objections, we'll adopt the record. Now open up the case for discussion for aggravating and mitigating factors. Make sure that you state your name when speaking, and also when you're bringing up a point, discuss if it's aggravating or mitigating. And we will open the discussion. Not everyone at once, though.
Copying for the record, I would open it up with, after reviewing the material, listening to the interviews, I found that there's an overwhelming amount of inaccuracies, responses, and statements that clearly, to me, fall in the category of moral fitness violation for dishonesty. I listened and read the mitigation. I find that the mitigation does nothing to sway me off of that determination, and I almost find that the mitigation adds to the aggravating nature of this case.
Thank you. Further discussion?
For the record, I would add that where there were inconsistencies or discrepancies, the usage of minimization was highlighted throughout this as well for me. Downplaying things that should have more seriousness or representation in somebody who starts this career at a very young age, that doesn't think it's important to document at a later time on a document, on a background check. And I think that there's proof in the material that minimization definitely existed.
Kevin Dresser, for the record, I would agree with that. It's a mitigating factor that it seemed by the material presented to me and that I read that this was clearly an extended service time as a reserve. I didn't buy off on this just being college credits and classes. It certainly was sufficient that he was performing law enforcement duties, both with regular officers, as typical of the reserve program, but also with some reserve programs where you were able to do solo work, and they had sufficient information that I reviewed that suggested that he did that on more than a few occasions. So to classify that experience as just college credit type thing and not a traditional reserve program performing law enforcement duties just didn't, just not there. And again, that minimizing that and trying to play on words and stuff just didn't resonate very well with me on that.
I just want to clarify for the record, you said at the beginning it was mitigating. Was that mitigating or aggravating?
Aggravating.
Okay, thank you for the clarification.
Livingston, for the record. I agree with everything that's already been said by others, but another aggravating factor for me was he made a point to talk about that time as unpaid work and really seemed to focus in on that as why he didn't include it in his background investigation. But he included the search and DCSO search and rescue time, which is also unpaid, and classified that as law enforcement experience, but then didn't do so for the work down in California. And so I felt that was aggravating. It really takes away that explanation as to why he didn't include it when he included the DCSO unpaid time as well.
Thank you. Scott Young, for the record, aggravating for me is his continued assertion that by providing a college transcript with a class title is sufficient for a police agency to research and find out what exactly he was doing. I think the onus is on someone getting into law enforcement, and it would certainly be in your benefit if you've done things to prepare yourself, such as being an unpaid reserve. And I can think of no circumstance where you would not include that unless it was a negative experience. You also have to think of the time in the 90s when law enforcement was a much more sought after position. The candidate pool was much bigger, and and I just think the things you needed to do to get into law enforcement were different than they are today. So the fact that someone would leave that out accidentally or not tell on multiple occasions, to me, is just beyond logic to me. So I find that aggravating.
Mark Daniel for the record. I have to agree on the aggravating circumstances, particularly around the time in La Mesa, California. He was obviously, based on the information we provided, a very active reserve. There was documentation that talked about a sergeant finding 5 citations in the basket, and the fact that he'd been involved in a pursuit, and a number of other things, and acting as a solo reserve as opposed to someone who's riding with another officer. That would be significant experience that one would really want to talk about on a application or in a process to be considered as a police officer. So I find it aggravating that was not included.
Patty Lofgren, public member, aggravating. Everything that's been said, to me, part of what was really difficult to see was the denial that he continued to make even after there was a reach out to La Mesa, reach out to LA, and the facts that they provided made it very clear that he was denying things that were obviously quite true. And that was very difficult for me, so that was an extremely aggravating situation.
Thank you.
Captain Dresser, for the record, building on those things too, most of what I read with regard to being confronted with that information was not a solid denial of no, but simply I don't recall. And from my own personal experience, starting my career as a reserve police officer, I recall 100% of those things because it was so important to me at the time and so new to me at the time. And again, if you're seeking that, your Chair Downing said with regard to getting into law enforcement at the time, that's how you got in, is that prior experience of being a reserve. So unless it was a negative thing, you would be articulating all that training experience to continue and obtain full-time employment. So, but again, going back to my point that most of his things were not solid no's and denials, they were simply that he just didn't recall, which I had a hard time believing.
Thank you. Scotty Downing, for the record, also his CV, the written information in the CV, and then to essentially blame that a third party writes this stuff. It's just really beyond belief that you would turn in a resume that could say really anything if you don't read it and proofread it. And so to say you have a master's degree from a university you didn't attend, or a bachelor's degree from a university you didn't attend, and to use the excuse that someone else wrote it, it just doesn't, it's beyond logic to me. And I think if you read the materials that were provided, I believe the correct information was in there at one point, and it just continued to evolve over time, which seemed to provide a more robust educational experience that just wasn't there. We just don't have documentation for it.
Mark Daniel for the record, and just follow along with that. I mean, there are multiple CVs that are in this document that we've been provided from year after year or a number of years, and they change multiple times through there. So the college experience is either there or it's not. There might have been one that I read that was actually reasonably accurate based on his actual education, but they kind of went back and forth and changed year to year.
Colleague, for the record, I would add regarding the CV that although it is possible to make mistakes on a CV, what is really hard to understand is how you then go in and testify under oath to the educational background. So really the mitigation provided holds no standing when you're under oath and testifying verbally under your own experiences. Additionally, I find it aggravating when I look at the review from the Deschutes County District Attorney's Office and this then subsequent Brady determination.
Rob Wood for the record, to expand on something with the job and volunteer, and the reason it wasn't supplied on numerous applications was it because it was college credits that he was paying for. Yet experience, as you've all brought up, is very important when you're a solo reserve. However, he had no problem sharing that with his field training officer during the Bend FTEP, because that was used as a consideration to accelerate his FTEP program. So I find that interesting that it wasn't disclosed as experience because it was college credit, yet it was disclosed to his field training officer.
Thank you. More discussion? Any discussion from anyone online, aggravating or mitigating? Hearing none? You want to review what we've...
I'm Cindy Park for the record. I recorded no mitigating statements, aggravating statements. There's an overwhelming amount of inaccuracies in the statements. The written mitigation is aggravating. There's inconsistencies or discrepancies in use of minimization. Made a point to talk about unpaid work, but didn't include it, but did include the DCSO unpaid time. It takes, I can't read my brain. Not including unpaid work from La Mesa, but including unpaid work from DCSO. Continue that college transcripts is sufficient in background information to DCSO. It was obviously a very active reserve, did solo work, significant experience, and would want to be a part of the hiring process unless it was in a negative experience. Denial, even after information from La Mesa was received, stating, I don't recall when asked questions about reserve time. No solid answers other than he did not remember. CV, the written information blaming a third party with educational degrees to schools that were not attended. Also aggravating multiple CVs in the documents, then they're changed multiple times year to year. In a CV, it's possible to make mistakes, but testifying under oath to those CVs is questionable. Review of the Deschutes County District Attorney's report and subsequent Brady designation of Sheriff Vanderkamp. And that experience as a reserve officer was used as a consideration in the field training officer program, but not in the background.
No, not at all. Does that reflect? Capture everybody's, see that?
Mr. Chair.
Anyone have anything that was missed? We'll now open discussion about whether or not there is a moral fitness violation. We have the following options. We can affirm the moral fitness violations that were identified by DPSST, which are dishonesty and misconduct. We can modify, we can make changes, or we can negate, which would remove it altogether. So we would call for a motion to affirm, modify, or negate the moral fitness violations as identified in the report.
Kevin Dress for the record, I move that we affirm the moral fitness violations that are in the report.
For both dishonesty and misconduct?
Yes.
Thank you.
Livingston, a second.
Thank you.
Right, we are voting on a motion to affirm the moral fitness violations as presented. Chair Downing?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Gilbert?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Thank you. We'll now look for a motion to either take action or take no action.
Probably for the record, I make a motion that we take action.
Connie will second.
All right, we are voting on a motion to take action. Chair Nowling?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Jovic?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend? Aye. Committee Member Wood?
Aye.
Motion passed.
Thank you. Next, we will call for discussion and a motion regarding the amount of time of the ineligibility period. You want me to go over it, or do you want to?
Chair, I'm happy to, Captain Calvin, for the record, because this includes dishonesty, the recommendation can be up to a lifetime.
If you do make a recommendation, it's just a reminder to, if you pick a amount of time, to follow up with some discussion on why you're picking that amount of time. So we can have a conversation about it.
Livingston, for the record, I'm recommending lifetime. I think that in this line of work and the level of dishonesty and inaccuracies throughout, and then the lack of accountability or any kind of remorse or acceptance of whether he wants to say it's a mistake or not. There's like no ownership for it. It's just basically giving blame back to others. And so I was not moved by any of the mitigating information provided and the level of dishonesty throughout the years and the testifying in court. I think it just raises to that level in my mind.
Barrett, I would second that, and with everything that she said, but with additionally adding that him and or his attorneys took steps to try to keep some of this quiet, up to and including filing a temporary restraining order application against the DCSO to prevent the release of the La Mesa documents regarding some of this stuff. The not signing of the disclosure agreement. So not only were there inconsistencies, accuracies, minimizations, but there were steps taken to hopefully keep some of this from coming out as well.
Public Member Lofgren, I'm just speaking as a public member, in reading through these files, the number of factors that, in a negative sense, gave me a sense that this is not a person who would make me feel safe in my community. This is not someone who I would want to be responsible for law enforcement in my community. It left me with a sense of fear and trepidation, and so I just totally agree that I would not want this person to be in this position.
Thank you. Scotty Downing, for the record, I will agree with what everyone said, but there's several committees and folks here at the Academy who are responsible for weeding out, and we've gone through a lot of procedures to weed out folks who come from other agencies and historically been able to hide their acts at previous agencies, and oftentimes another agency will hire them. And so there's been safeguards put in place legislatively, administratively, and committees that are trying to identify these situations exactly like this, where someone has a history from another state, and there was multiple opportunities to provide that information on multiple different forms, and Sheriff Vanderkamp just did not. And so it did get exposed eventually, and so now here we are. So I agree with what everyone else has said, and if there's no other discussion, we have a motion and a second.
We are voting on a motion for a lifetime ineligibility period. Chair Nowling?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Jovic?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Thank you.